Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be talking about basics of the right to know law. Hey, let's cover a couple preliminaries before we dive into the session. First offhand, this session is essentially a PowerPoint presentation with me talking in the background. The PowerPoint is available on the OOR's website. You would scroll over to the training tab, go down, and you can find all of the PowerPoints that the Office of Open Records uses for its training sessions and webinars. You're welcome to use any of them. Maybe you have some coworkers who couldn't make it this morning. Maybe you're thinking about conducting some local training, and maybe you just need something for your own future reference. So these webinars or these PowerPoints are available for you to use as you see fit. Also, this session is being recorded, and the recordings as well are saved. Within a couple days, they'll be uploaded to our YouTube channel, and from the YouTube channel, the most recent webinars are typically copied over to the website as well. Again, go over to the training tab, scroll down, and you'll find the most recent webinars. And again, you're welcome to copy or link to those as you see fit. Again, maybe you have some coworkers who couldn't make it today. Perhaps you want to have some wider training at the local level. And again, maybe you just need them for future reference. We consider them public records, so you're more than happy to use them as you see necessary. As far as the session goes today, if you have questions, you can type them in the chat feature, and it'll come up on my screen. I will do the best I can to answer your questions as we're going through the webinar. But I have two conditions. First is that we're talking about the right to know law. So let's stay on topic, okay? And more importantly, if you can keep your questions as succinct and brief as possible, that really helps. Sometimes folks will type in several paragraphs all at the same time, and it's just awkward for me to sit here and read through it while everyone else is waiting patiently. If it looks like you've got something that is unusually complex or specific to your situation, we'll do one of two things. I'll wait until the end of the presentation and then try to scroll back and address it at the end of the presentation, or we'll take the conversation offline. The contact information for the office is on the screen right now with the phone number and the URL for our website. Feel free to reach out to us, at any time. Where we have administrative staff who are manning the phones, just waiting for you to call. And they are very good at getting you pointed in the right direction. If by chance you have something that stumps them, at your request, they can escalate it up to one of the senior executives. And we're usually pretty good about getting back to you within 24 hours because we figure, if you're contacting us, you've got something important. And given the nature of the right to know law, it's time sensitive. So you need an answer quickly. We do our best to help you out there. Now, a couple things. We can't write requests for you. We can't answer requests for you. And we can't talk about any active appeals that we have currently in the hopper. Also, we can't provide legal advice. That's just inappropriate for us to do that. But what we can do is point you to legal decisions where the facts are very similar to the situation that you might be putting in front of us, so that you know how our office or the courts have ruled under similar circumstances. So like I said, we'll do everything that we legally can to get you pointed in the right direction. Feel free to reach out to our office. Okay, other than the location of the bathrooms, I think that takes care of all the preliminaries. So let's dive into the right to know law. And I want to begin by talking about, why it's important and some fundamental statements. First offhand, let's talk about access, transparency, and good government. Okay, the right to know law is now going on its 13th year, I guess, since it's, well, actually 14th year. since it was invoked. And yeah, I've been around for all those. It speaks to access, transparency, and good government. I like to begin with a fundamental statement that, if you're here either as a requester or you're a right to know officer or open records officer, those two titles are interchangeable. I think it's important to be aware of what the right to know law is all about, and its purpose is to give the public access to public records. Okay, nothing more, nothing less than that. There is sometimes a misunderstanding that people see that term right to know and they envision it as some form of Google for state and local government, and that's just not the case. It's been, sometimes entertaining to see some of the right to know requests that people will submit. Or I've had conversations with people who, maybe they were a little unhinged, maybe they were frustrated, but, shouting at the top of their lungs on the other side of the phone, I have a right to know, I have a right to know. Okay, well, maybe you do, but in the context of the right to know law, you have a right to access public records, and that's pretty much it. There have been times where we've received contact from an open records officer who, they receive a right to know request, and given the way that it's worded or the context that it's submitted in, they're not quite sure what to do. And I'll often advise them, go back to this fundamental statement, and oftentimes that will get you headed in the right direction or get you back on track as to what your responsibilities are. Again, I'll repeat, give public access to public records, okay? And that's the exercise that kind of begins the conversation, that gets us started on how we respond to right to know requests. Okay, now, given that, it's important that you remember the starting point is that every record of an agency is presumed to be public. Okay, that's where you start. Nothing is secret when you first begin. Okay, everything that an agency, and when I use the term agency, I'm talking about state agencies, cabinet level agencies, boards, commissions. At the local level, we're talking about cities, boroughs, townships, school districts, and as an extension of school districts, public charter schools, authorities, any government organization or quasi-government organization established by statute, okay, would fall under the jurisdiction of the right to know law. So your starting point is that every record that we have is public. Now, what if a right to know request is received and a red flag goes up? It's like, I'm not sure about this. Something just doesn't seem right that we should probably not be giving out this record to the public, okay? If that's the case, then chances are there is a tool available in the right to know law or another law that may deem that record as confidential. However, if that's the case, it is the agency that bears the burden of proving that a record is not public, okay? And just a little bit of history. Prior to 2010, when the right to know law was enacted, Pennsylvania had what was called the Right to Know Act, with its genesis going back into the 1950s. Under that act, if someone submitted a right to know request and it was denied, the requester had to take the agency to court, and the requester had to prove that the record was public. Right to know law, 2010, that flipped 180 degrees. Now it is the agency that must successfully make a legal case as to why a particular record should not be released into the public domain. Okay, so that kind of sets the stage. Questions come up. Is a local agency appeal to common pleas from a final determination de novo, or does another standard apply? I'm going to have to say, Jeff, that it depends. In most cases, yeah, we're talking about common pleas. It really depends on the court, and we've seen it go both ways. Commonwealth Court definitely is de novo. Common pleas, more and more, the higher courts, Commonwealth and the Supreme Court, are saying, you know, you only get one bite at the apple, and if you didn't raise the issue before the Office of Open Records, you don't get a second chance with common pleas, okay? Now that is not, oh boy, I'm just going to say this is my impression. It's not a legal, you know, I'm not giving you a legal affirmation here. It's going to depend on the court. It's going to depend on the issue. I think it is an evolving area of the right to know law. We have seen some decisions coming down from Commonwealth and Supreme Court where they said to the agency, look, you had your shot before the Office of Open Records. You didn't raise this issue. Now you're attempting to raise it before the County Common Pleas Court. That's not going to work. But then we've had some others where the agencies have successfully raised issues before common pleas that they did not raise before the Office of Open Records. We're going to allow that. I guess the best thing to say is, number one, it depends. Number two, it's fact specific. Number three, it could also depend on the Common Pleas Court and how they approach the issue. I just can't give you a definitive yes or no at this point, but that's a pretty good question. Okay, so we've talked about agencies bearing the burden of proving that a record is not public. Certainly a foundational concept of the current right to know law. Let's move on. A point that I think is very important to make is that the right to know law is not a confidentiality law. Okay, what do I mean by that? Well, first offhand, there's nothing in the right to know law that prevents an agency from simply giving out a public record. I can, walk into an administrative office, let's say it's budget season, and there's a stack of budgets there on the counter. There's nothing preventing an agency from simply giving me a copy of the budget, and I walk out a happy camper. Let's, change the example a little bit. Let's say I walk into the office with a right to know request for a copy of the budget, and there's a stack of budgets sitting there. There's nothing preventing the agency saying, you know what, Mr. Spees, if you tear up that right to know request, I'll hand you a copy of the budget. It'll save me a lot of work, and it'll save you a lot of time. Why wouldn't I want to do that? Okay, because I'm getting what I'm asking for, and I'm getting it right then and there. I don't have to wait for a written response as mandated by the right to know law, and it's absolutely nothing illegal. Now, if I were to say, no, I want to follow the right to know process, well, then we have to do that. But then, I risk waiting up to 35 days before I get a final response. So, there's flexibility built into this. And I'll establish a central theme right now. There's also nothing in the right to know law that prevents people from talking to each other, okay? You get a right to know request, it's a little unclear as to what the person might want, or, maybe you can steer them in a proper direction or whatever. Absolutely nothing preventing you from picking up the phone or sending an email back to the requester saying, hey, this is what's going on. Maybe it'll help you out, okay? Absolutely nothing preventing conversations with each other. Communication is good, okay? Now, also on the agency side, there's nothing in the right to know law that says a person must submit a right to know request in order to get a record, okay? If your agency is receptive to it, a person can simply call up and say, hey, I need a copy of this form. or I need a copy of this approved building permit. Can you send it out to me? You can say, sure, we'll put it in the mail this afternoon, or you can say, I'm sorry, we require that you file a right to know request to get those records. Okay, the agency is afforded a fair degree of discretion in how they establish its open records program under the right to know law. Okay, now what we recommend here at the Office of Open Records is that you be a bit proactive. Take a look at your right to know requests and identify patterns of records that people are requesting. And then if you have a website or social media, put those records out on your website, okay, before people request them again. The right to know law allows that when you receive your next right to know request, that you can simply respond, that record is on our website, here's the URL. And that is a completely acceptable and legal response. Now, when you do that, you'll notice a couple things. The hits on your website start going up because now you're using it as a business platform. And right to know requests will start going down, which usually is a lot less work for the agency, which is also a good thing. Okay, so stuff like, budget materials, any contracts that people may have questions about, salaries for public employees, clearly a public record, purchasing documents, and the like. All stuff that people would typically request where there's no confidentiality provisions, you can put out there on your website. And it's the way the public is used to doing business nowadays. They would much rather sit in the comfort of their family room, pull out their laptop, scroll your website to get the records that they need, as opposed to potentially taking an afternoon off from work, having to come down to Borough Hall or Township office or whatever, filing a right to know request, and then potentially waiting over a month before they get a response to their request. Okay, so yeah, it's just good business, it's good government, it's good customer service and the like to put these records out there as much as you can ahead of time to save yourself a lot of work and to accommodate the public with whatever records that they might be looking for. Okay, another question has popped up. Hi, Jeremy. Can you please clarify what the Office of Open Records means by sworn affidavit? Okay, for an appeal. Well, two terms, an affidavit or an attestation. Now, we talk about this, well, actually, I don't really mention this towards the end of this presentation, but what Jeremy is referring to is that in meeting your legal burden, if an appeal is filed, okay, this is all after we get through the right to know request process. And let's say that the requester is not satisfied, so they end up filing an appeal before the Office of Open Records. Well, anything submitted by the agency to the Office of Open Records in order to make its case before the appeals officer needs to be supported by either an affidavit or a sworn attestation. And I'll give you a quick example. Let's say that a person is requesting a record that you simply don't have. Okay, so you respond to the person saying, we're not in possession of that record. But for whatever reason, they don't believe you. They're not satisfied. So they file an appeal. Now, in the past, an agency may just send us a note saying, oh, we don't have that record. Well, unfortunately, because an appeal is a legal process, basically someone is suing your agency, and the Office of Open Records goes into court mode at that point. Anything that the agency submits to us needs to be supported by a sworn affidavit by the appropriate employee. So if it's by the open records officer for the agency, they need to sign an affidavit basically saying, I'm the open records officer, I'm the person responsible for all the records within our agency. I have conducted a good faith search of all our records, and I have determined we are not in possession of this record. And I sign this affidavit under penalty of perjury. that, I'm paraphrasing there, and your solicitor will know what an appropriate affidavit looks like and the language it should contain. But Jeremy, that's pretty much it in a nutshell. You can't just send us a note saying we don't have it. You have to send us an affidavit saying we don't have it, and it needs to go into detail. Okay, and there's actually some case law on this where the courts have come back and said even this affidavit isn't clear enough as to the nature of the search that was conducted by the by the agency open records officer. And I don't want to get into the weeds here, but it's a very good question. And it also kind of highlights the fact that you don't just rely on the right to know law and the language in it, but you also have to rely on case law, which is always changing. There's probably a new court decision coming out, I'm going to say once a week, and the important ones, maybe once a month. And the courts have weighed in on these affidavits and said, look, it can't just be conclusory. It has to get specific. Just 2 weeks ago, or was it last week, we did a webinar on specificity, and Nathan Byerly got into a little bit about writing good affidavits. And if you're a solicitor joining us today, and even an agency open records officer, you need to be aware of this when you're at the appeal phase of the process, making sure that you meet your legal burden appropriately. Okay, good question. Sorry to get off track here, but let's try and get back with what we're talking about and move on here to the next slide. Okay, let's say that the agency is under the jurisdiction of the right to know law. No surprise there. There are some things that you must do. And probably the most important is you have to appoint that agency open records officer or right to know officer. Okay, the two titles, like I said, are interchangeable. We call them arrows. Okay, this is the person responsible for receiving, processing, and responding to right to know requests. There's nothing in the law that says they have to be at a certain level within the agency. It can be a clerk sitting at the front desk. It could be the mayor. It could be the board chairperson. It could be the school district superintendent. Also, you can have more than one arrow. You just have to make sure that the person, the requester, knows who do I give this right to know request to. Okay, because like I alluded to earlier, there are hard deadlines built into this law. So you don't want any unnecessary delays. Agencies can come up with their own rules when it comes to the administration of their open records program, as long as they're not in conflict with the right to know law or anything that has been promulgated by the Office of Open Records. For instance, there is a provision within the right to know law that says you can accept anonymous, or it says you may accept anonymous requests. Now, in Pennsylvania, there's also another law called the Statutory Construction Act. And it so happens, because the right to know law uses that word may, it also means may not. Go figure. Okay, so that means that an agency could pass a rule that says we will only accept right to know requests where the person is identifying themselves. We will not accept anonymous requests. Okay, so that, like I said, that gives the agency a fair degree of flexibility. And there's other examples as well. You can come up with your own right to know request form. Most agencies do. They like to have their seal at the top, perhaps information on who the arrow is. But you also must accept the uniform request form, the state form. It's on our website. There's not necessarily anything special about it. Many agencies will simply link to that as well, and that's fine. And then finally, we ask that you tell us who you are, because on our website, we have a database of arrows across the state. Some of it relies on voluntary compliance. And we realize, arrows move on, they get promoted, they retire, they move from one agency to another. And it's important that we keep this up to date. So maybe a takeaway is check this database out today. And if it's not up to date, there's a form there for you to fill out. Email it to us, we verify it, and then we update the database, okay? Can we make them fill out a form instead of just an email? I've got numerous emails with generic forms, but put the, yes. Brenda, if you want to require that, that in order for a right to know request to be valid, they must use either your form or the state form. The right to know law allows you to do that. Okay, let's move on. And let me get a sip of coffee. Yes, under the right to know law, you're required to have postings. Those postings, they must be on bulletin boards physically within your offices. And if you have a website, they must be on your website, okay? You're not required to have a website, but if you do, you have to have right to know information on there, okay? The postings must have contact information for the arrow. Remember what I said. If I'm a member of the public, who do I give this right to know request form to? So you need to have that posted. Then you need to have contact information for the applicable appeals office. If my right to know request is denied, what do I do? Okay, well, typically you would have them reach out to the Office of Open Records. And I would recommend simply posting the URL to our website because most of the work we do is online. Then you need to provide a form so that if they don't have one, and like Brenda said, if you're requiring that they use a form, you need to have a blank one available for them to use. And then any of those local regulations, policies, or procedures that your agency may have enacted in addition to what the right to know law says. Okay. Do we have to have a policy stating they must use the right to know form? It's a good idea to have that policy, okay? It doesn't need necessarily, when push comes to shove, it doesn't necessarily need to be in written form. It can simply be an acceptable use policy that this is what we do. But ideally, you should have an open records policy in writing that's adopted by your elected officials, okay? That's ideal, okay? But it's not necessarily required. You can simply have a practice that we require a right to know form as long as you apply it equitably across the board and don't say, well, you need to use the form, but well, I like you, so I'm just going to give you the record without requiring the form. Okay, don't do that. All right, moving on. Let's talk about some things that you can't do using the right to know law. Well, first is that you can't adopt a policy where you limit the number of requests or the number of records that a person asks for within a specific time frame. You can't say something like, ma'am, I'm sorry, you've already requested 3 records this week. That's all we allow. Okay, if she wants to submit a right to know request for, or 12 right to know requests this week, the law allows her to do that. The other thing that you cannot do is compel a person to tell you why they are filing a right to know request. You can't deny a right to know request based on the reason or what you think the reason might be. And maybe you think they're filing a right to know request just to see you work harder. Okay. Unfortunately, you have to respond. Now, I'll just go off. I'll get on my soapbox here real quick. The majority of people, the greater majority of people, submit right to know requests because they have a legitimate reason they need a record. But there are a handful of folks out there where, for whatever reason, the relationship between the agency and that person has broken down. So they've decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is to weaponize the right to know law. Okay. There are things that you can do. Okay. And typically, you want to take a look at the payment side of the right to know law. Now, we're going to discuss that briefly during this presentation, but we also have another webinar that deals specifically with the payment side of the right to know law, payment issues. You want to sit through that because I can get much more specific. And I'll simply say that the solution to dealing with problem requesters typically is on the payment side, because quite frankly, the right to know law is not free. A lot of people think it is, but it's not. And usually people who are being a pain in the neck aren't willing to pay to be a pain in the neck. Okay, so you see where this conversation is going. All right, so let me go back on script now. And Melissa, I think I just answered your question. Sherry, what if you have to create a document they are requesting? Okay, very good question. Under the right to know law, and there's a specific clause that says you do not have to create a document in order to respond to a right to know request. But I'm going to say two things. Number one, if someone is simply requesting a short list of something, sometimes, you know, you weigh the factors and like, what's the path of least resistance? Maybe I should just type out a list real quick and I'll send it to them. Okay, then, you know, the problem goes away. You've responded affirmatively to the right to know request. You weigh that versus, okay, I respond back and say, I don't need to create a document. So this person files an appeal. Well, now that's going to create a lot more work for me. The solicitor's going to get involved. It's going to cost, you know, the township or the borough or the agency a lot more money, just because I wasn't willing to sit down and type out a quick list that this person asked for. Okay, sometimes, you know, maybe the law is on your side, but the path of least resistance is saying, just type out the list, give the person what they're asking for, and they'll be happy, I'll be happy, and we move on to the next job duty that I have to do. Okay, and then there's case law. Okay, I keep mentioning this and why it's important. Gingrich versus the Pennsylvania Game Commission. Okay, and it involved this very issue. And I'll just summarize it real quick. The court said that the database is the record, and that the spreadsheet that the Game Commission had to create is simply a report reflecting the record. Okay, I don't have time to go into great detail there, but there is, you know, what I'll call is an exception to the you don't have to create a document rule. Okay, maybe just given the specifics of the situation, you would have to create a record in order to legally respond to the right to know request. Okay, it doesn't happen a lot, but you do, you know, given the circumstances, you might want to take a look at that Gingrich rule. Again, going back to our website, which by the way is the best government website you'll ever see, we have a case law index and it specifically mentions Gingrich. And, you know, if you've got a couple extra hours for some on the edge of your seat reading, you can go through our case law index and take a look at how the courts have ruled on the exciting world of right to know. Okay, you can tell I'm in quite a mood this morning. All right, let's move on. I can tell we're way behind here, but that's okay. I like to describe the right to know process as an obstacle course. This obstacle course, you know, it has its start, and on the obstacle course, there are 2 hurdles. In front of the second hurdle, there are 3 hoops. It's only when you get through the obstacle course that you end up basically concluding that it's a public record, which we're going to release. Okay, question has popped up here from Jeremy. Someone was recently asked for our bank records. Okay, again, it's going to depend, yeah, what you have in your possession, what's on those bank records. You know, like you can limit certain account information that you want to give out. We did not have the 2019 records in our building. Our online banking website, is that creating a record? Oh my. Well, I think you would have to argue whether or not the bank records are in fact in your possession. I'm not aware of any case law that specifically deals with that. You do have access to them, but they're not necessarily your records. And then there's costs. You know, you're talking about electronic records. Jeremy, I Boy, I'd have to think this through, and I just can't give you a definitive answer right now. I think in most cases, we've ruled that if you have them in your physical possession, you would give them out. If you don't necessarily have them readily at hand, you don't have to conduct research, and we use a very liberal approach to the term research. Yeah, I'm hesitant to give you a definitive answer at this point. I know we've dealt with this in the past, but I have to go back and see whether we have any decisions. I would say take a look at our final determinations database on the website and see whether or not the issue of bank records comes up, and then take a look at whether or not electronic bank records has ever really been definitively ruled on by any of our appeals officers. Boy, you guys are asking some good questions today. My hats are off to you. Or my hat is off to you. Okay. All right. So let's talk about this obstacle course that we have here. First offhand, receiving a request. The way the law reads is that when the arrow receives the request, they need to note the date that it comes in. Okay, that they get it, because, like I said earlier, there are hard deadlines built into this law. No wiggle room. So you note the date, because now the agency has 5 of its business days to provide an initial response, okay? If I receive the request today, provided the office is open, tomorrow is my first business day, okay? And I say 5 of your business days because not all offices are on a Monday through Friday schedule. I can go up into the northern tier of Pennsylvania, walk into a township office if they're open, and maybe they're only open 1 day a week. So 5 business days would be 5 weeks by counting it out. Saturdays and Sundays, not business days. If you're closed for a holiday, it's not a business day. If you're closed for an emergency weather event, that's not a business day. So you count out your 5 business days. That's when your initial response is due. We call it an initial response because part of your options are that you could invoke a 30 calendar day extension, which I'll talk about. Oh yeah, I have it here on the bottom of this slide. No, I think it's in the next slide. But you have that option where if you cannot provide a final response within the 5 business days, the right to know law allows you to invoke 30 calendar days. Okay, maintain a copy of your request. Now, the right to know law says 30 days or until all appeals have been exhausted. Now, if it ends up getting appealed all the way up to the Pennsylvania Supreme Court, that could take several years. So you want to hang on to stuff. Within Pennsylvania, though, there is another law. It's called the Pennsylvania Municipal Records Act. If your municipality has adopted this law, that says hang on to everything for 2 years. After 2 years, provided there's no appeals pending out there, you can dispose of it. I would really recommend that you take a look at this Municipal Records Act. It deals with records retention in general, not just the right to know law. But after 2 years, if there's no need to keep any of the records related to a right to know request, you can get rid of it. Okay, you can just dispose of it as you see fit. Okay, that's the standard that I would recommend. Questions come up. If the request comes into the agency, but I did not receive it for 3 days because someone was on vacation, which dates apply? Oh my, Vicki, you're right on point here. It's case law. The right to know law says when the request is received by the agency open records officer. So if your arrow is on vacation, the clock does not start ticking until they come back from vacation. Now, when that happens, communicate to the requester the fact that the arrow is out of the office. They won't be back until this date, so they should expect, everyone's on the same page when it comes to the deadlines, okay? So that if they don't receive a response when they're expecting it, they don't go around and file an appeal, which would otherwise be premature. Okay, and case law backing this up, Office of the Governor versus Donahue. Okay, that's the case that you want to refer to in case your solicitor has any questions. All right, what if you work 3 days in the office and 2 days remotely? Do the remote days count? No case law to support that, but off the cuff, I would say probably they do. Okay, you're still working as far as your office is concerned. Is the creation of a spreadsheet only to respond to an investigation considered an agency record that must be provided if it were to be requested? Okay, you're raising another issue here dealing with an investigation, and I'm going to say that's fact specific. Depending on the nature of the investigation, there may be what's called an exception that would allow you to withhold a record. Could be a criminal investigation, could be a non-criminal investigation. And it's possible that one of the exceptions would apply here. So I'm not going to take a chance at answering your question because you're raising the issue of creation of a record and muddying it by saying it's could be part of an investigation. So you may not have to respond at all. Or you would have to respond, but your denial would be based on the investigation parameters, not necessarily the creation of a record parameter. So your question is just a little too complicated for me to provide a definitive response there. Okay, time to move on here. Hot bench today, and that's okay. I mentioned extensions, okay? If you're not able to determine an initial response or final response within the 5 business days, the right to know law allows the agency to unilaterally, you don't need the requester's permission, you can unilaterally invoke a 30 calendar day extension. Okay, calendar day, you basically pull out the calendar and count 30 days. Saturdays and Sundays do count. Office closings do count. Holidays do count now. All right, but in order for the extension to be valid, conditions need to be met, and you'll find these in the right to know law. First offhand, you need to invoke the extension within the initial 5-day window. You can't wait until what otherwise would be the 6th business day, suddenly realize, oh, I forgot about this right to know request. Well, I'll just take an extension. Unfortunately, when you miss the deadline, you are in essence denying the request by default. It's what legally is called a deemed denial because you missed the deadline. All right. And the other condition is you need to notify the requester in writing that you're taking the extension. And, you know, if they submit it by email, you can email them back. We're taking an extension here. Then you need to provide them with a reason. Fortunately, in section 902, there are 6 reasons listed, and you simply choose the ones that are appropriate. We keep these records off-site, and it's going to take us longer than 5 days to go dig them out. Or we want our solicitor to review these to make sure we're not giving out anything we're not supposed to. Or we simply are under a staffing crunch right now. And due to manpower considerations, we don't have time to get these out within 5 business days, okay? Like I said, right to know law gives you a lot of flexibility. Then you provide the date when the requester can expect to get the records. Usually it's on the 30th day of the extension. And then you give them an estimate of what you think it's going to cost them. And it is just an estimate. It's not a hard quote. Okay, it can be a little higher, it can be a little lower. You settle up on the exact amount when you provide the actual records. So you've got your 5 business days, and then you can tack the 30 calendar days onto the end of those. Okay, and that's how long the agency has to respond to a right to know request. Now, if someone submits a request and the records are readily available and clearly public, please do your best to get them out right away. Nothing is more upsetting to someone when an agency, just as a matter of practice, kind of attempts to throw cold water on the right to know process by automatically taking that 30 calendar day extension. Okay, if you don't have to, don't do it. But I realize also that many agencies are only one person deep. They've got more than enough work to do, and they have to take the extension. I realize that happens a lot, but there's also those agencies out there that don't necessarily have to do it, but still do it, okay? If you can get the records out to the person, or I should say, get the response out to the person within the 5 business day deadline, that's what you should be doing. Okay? Now, let's move on and talk about the first hurdle that we're coming up against. And we need to answer the question, is the person requesting a record? Well, you're thinking, well, that seems rather obvious. But what I tell folks, whenever you're trying to understand the law, and for our purposes here, the right to know law is fairly easy to understand. For the most part, it's written in common English without a lot of legalese. It's not a necessarily long law, okay? But, there are some areas where it helps to understand exactly what they're talking about. And I always tell people, when you're trying to understand the law, go to the definition section, because a lot of times it helps explain that vague language. It sheds light on provisions within the law that may appear to be in conflict with each other. If you go to the definition section, and the right to know law is no exception to this, a lot of times it provides the needed clarity. And sure enough, within the definition section of the right to know law, it defines a record. A record is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase there, highlighted in red. Documents a transaction or activity of an agency. That means that the record needs to be about our borough, our school district, our authority. And it needs to be about what we do. It needs to be about our mission. It needs to be our responsibilities. It needs to be about our duties, okay? So you're thinking, well, why would we have anything that isn't about what we do? Well, here's a quick example. Let's say I'm an employee and I send an email to one of my colleagues. Hey, you hear about the restaurant that opened up downtown? Let's do lunch tomorrow, okay? Has absolutely nothing to do with the mission of the Office of Open Records. It's simply saying, let's go to lunch. Okay, it's a fairly common sort of communication that you might find in our emails, but because it has nothing to do with the mission of the Office of Open Records, under the right to know law, it doesn't rise to the definition of a record. So think about it. Meeting for lunch, I'm going to bring home a gallon of milk on my way home from work tonight. Or what do you guys think about the trades that the Eagles have been making and their chances for this season? Okay. Yeah, all common sort of communications that you'll find in an office environment, that because of the fact that they don't meet the definition of a record, they're not considered responsive under the right to know law. So they're off the obstacle course. Okay. You don't have to worry about stuff like that being released through the right to know process. Only those records that document a transaction or activity of the agency would be considered rising to the definition of a record, thus making it over that first hurdle. Okay. Something else that I want to emphasize here is the use of personal devices. Okay. Let's turn the tables a little bit. Let's say that now I'm at home in my family room using my personal laptop, using my personal Gmail account, and I send a message, I send an email to one of my coworkers. Would you send me the case files on this particular appeal that we ruled on last month? Okay, because I need them for reviewing some questions that I've received or some training that I'm going to do. Okay, the mere fact that I'm using my own laptop and my personal Gmail account, which would be against agency policy, by the way, but let's say that I did it for some reason. Let's say I did that, okay, has no bearing on whether or not that email would be considered a public record. It is the content of the message, not how it's created, how it's stored, how it's sent, et cetera, that determines whether or not it's a public record. Okay, so there's nothing illegal about using my cell phone or my personal laptop for agency business. It's just that there is a court decision that says you cannot use personal devices and personal accounts to hide the public's business. Okay, so you need to be aware of that. Nothing illegal about doing it. It's just that those messages are considered discoverable under the right to know law. All right, moving on. Now we come up to the second hurdle, and it's a big one because we've got 3 hoops in front of us. We have to answer the question overall, is it a public record? Notice the distinction. First it was a record, now we need to answer, is it a public record? And to do that, we need to make it through these 3 hoops. The first one, do any exemptions apply? And if so, are we going to invoke them? Okay, what the heck is an exemption? Well, you go to section 708B of the Right to Know law, and there are 30 exemptions, 1 through 30. An exemption is a definition of a record that the agency has the discretion to withhold from public release. And it covers a broad scope of records. And when you look at them, they're things that common sense tells you, well, yeah, we would never give out a record like this. For instance, there's an exemption that basically says, if by giving out this record, it would put someone in physical harm, okay, at risk of physical harm, you can withhold it, okay, no brainer there. Another one that says, if by giving out this record, we would risk the security of our computer systems, you can withhold it. Then there's others that say, you know, you don't give out health records for employees. There's another one that says, if this involves a minor, we would not give out these records. Stuff like that, okay? And like I said, there's 30 of them. All 30 have been tested in the courts or through the final determination process. So, you know, there's legal basis for withholding these, okay? Now, the other point that I want to make is that under the right to know law, it's discretionary, okay? The right to know law does not say, remember, it's not a confidentiality law. It doesn't say you must withhold these records. It says you can withhold these records, which also means you can give these records out if you want to. However, that brings us up on the second hoop, which we have to answer the question, are there any other federal or state laws or a judge's order that says these records are confidential? And it so happens there are a host of other laws that protect certain records. Okay, we actually do a webinar on these other laws. It's called Laws That Protect Information. And we go into detail on some of these laws, the ones that we most commonly come up against, that say these records must be withheld. For instance, in Pennsylvania, there's a law called CRIA, the Criminal History Records Information Act. Now, the right to know law gives you the discretion to release criminal investigatory records. Okay, you can release them if you want to. Usually you don't, but let's just say there's certain circumstances where you're thinking, yeah, maybe we'll just give these out. However, CRIA, the state statute, does not give the agency the flexibility or the discretion to release those records. CRIA says you may not release these records if you happen to be a law enforcement agency. Okay. And if there is another law, listen to this, if there is another law that contains a confidentiality provision for a record that you have in your provision or in your possession, that law trumps the right to know law. Okay, you would go to section 306 and you can read the language. It says that the right to know law does not modify the provisions of any other law that deems a record confidential. And if you have one of these other laws that usually does not allow discretion, usually it says you may not release this, that other law prevails. And many times it also includes sanctions if you do release the record. So you need to be aware of what these other laws are. Now, if there aren't any other laws, then you've made it through the second hoop, And now we come up against the third hoop where we have to answer the question, is the record protected by privilege? Typically, this is attorney-client privilege. And that is anytime there's an exchange between an attorney and their client of sensitive information that is considered confidential. And it's protected by statute and the rules of evidence in Pennsylvania. And it's also specifically mentioned in the right to know law under section 305. Okay, so it's there, and you need to be aware of, for our purposes, it's usually any communication that's documented between a solicitor and the elected officials or senior management of the agency. Okay, for instance, it could be an email coming from the solicitor to the board regarding questions that were raised at the last public meeting. Okay, just legal advice or some legal product of some sort. Okay, protected by attorney-client privilege. Okay, so that would not be released to the public. All right, so let's go back and take a look at these hoops. There's no exemptions that apply, or if there are, we've chosen not to invoke them. There's no other laws that say these records are confidential and they're not protected by privilege. Okay, we've made it through the three hoops. Now we can jump over the second hurdle. And when we do that, we're saying these records are public and we're releasing them to the public in response to the right to know request. Okay, you've successfully maneuvered through the obstacle course. Congratulations. All right. So now we need to write a response, and the person needs to pay for the records if there are costs involved. Okay, well, the first thing that we want to talk about is that the agency is only required to provide the record in its current medium. What the heck does that mean? Well, it's electronic versus hard copy. Okay, you go to section 701, and I'll paraphrase here, but basically it says that you only need to provide the record in the medium in which it exists. So if someone submits a right to know request, let's say it comes in through email, and they say, I want these records emailed back to me electronically. And they would do that first because it's easy, and second, because there's no cost for electronic records. Okay, makes sense. But let's say the agency only has these records in hard copy. Maybe it has to do with building permit approvals. Okay, so the building permits are only in hard copy form. Well, the agency can reply back and say, we only have these in hard copy, so we're willing to grant your request, but you're going to have to pay for them. Maybe the person isn't willing to pay for them. So you would end up, in essence, denying the request because the agency is not required to scan the hard copy records in and send them to them electronically, because that would be converting them from one medium to another. All right, and then like I said, there's no charge for electronic records. All right. Under the right to know law, there's two ways you can request to see records. The one we've been talking about is making copies. The other is what's called inspecting, where the person can say, I want to come into the office and view the original records. If you've determined that they're public, then they can do that. However, the agency is in the driver's seat. Let me get a sip of coffee here. It is the agency that determines when it is convenient, given their schedule during normal business hours, that the person can come in and look at the records. The agency can supervise the inspection to make sure that nothing is altered, stolen, or destroyed. However, if the person pulls out a cell phone camera and takes a picture, they are allowed to do that. Okay, they can make their own copies. They can bring in their own copying equipment as long as it's not upsetting or gets in the way of office operations in any way. The agency can't charge for labor. They can't charge for the act of redacting They can't charge for any sort of legal review. That's simply the cost of conducting the public's business. You can only charge for actual costs, things like postage, or if you had to make a large copy and go down to Staples or Kinko's, whatever they charge you, you can pass on those costs to the requester. We cover all this in detail in the payment issues webinar. Okay, I keep talking about communication. Okay, so no surprises. Don't bushwhack a requester with expenses that they're not expecting to get. Many people might think it's free. Something just came up on the chat feature, a bunch of blank lines. I don't know if that's a question or not. I'm just going to let it go for now, but it came from Hargett Robinson. I'm not sure whether you were trying to submit a question or not, but it didn't come through properly. All right, back to the slide. There is absolutely, like I said earlier, nothing preventing an agency from picking up the phone and talking about, talking with a requester to clarify a request, or there's nothing preventing a requester from calling in to get clarification on how the process works. But try not to surprise people with costs that they may not be expecting. Now, when it comes to payment, okay, I talked about the deadlines, the 5 business days to 30 calendar days. Folks, if you look at the right to know law, that applies to when the response is due, not when the records are due. You can provide a response that says your request is granted within the deadlines, and then say, we'll provide the records when you provide us with payment. And when your check clears, then we'll mail out the records to you. Okay, you can do that, okay? I'll repeat myself. The deadlines apply to the responses, not when the records are provided. Okay, now, what if you get a really big request where the response is going to exceed $100? The right to know law allows you to kind of demand what I call a security deposit. Send us a check for the total cost of the records before we even begin processing your response. Okay, that way the agency doesn't get stiff with making all these copies, doing all this work, and the person then balks at payment because now you've got that security deposit. Okay, and then like I said earlier, you settle up on the exact amount when the records are actually provided. Okay, if by chance someone submits a right to know request, you do all the work, the agency does all the work, has the records, that person has 60 calendar days then to pick up the records. If they fail to do so, you can dispose of those records. However, the cost does not go away. If the person still owes money for the work that was done for the records that they failed to pick up, you can withhold any further right to know response until that debt is settled up. Okay, let me repeat that part. If someone owes you money for a previous right to know request, you can deny any further right to know requests from that person until their account is settled up. Okay, however, if you do that, make sure all your I's are dotted and your T's are crossed, because if you deny a request for non-payment, that person can appeal. And the appeals officer is going to want to see all the records that led to your conclusion that there is an outstanding debt. And the records need to be in order, okay? Again, you can go to our final determinations database, put in on the text string the word fees, and dozens of cases will come up where the issue was whether or not the person owed any money. And you can kind of see how the Office of Open Records has ruled on these cases. All right. Let's talk about a denial letter. Okay. Let's say that you didn't make it through the obstacle course. Well, the agency now must provide you in writing the denial letter. And this is important because remember at the beginning, I said it is the agency
that bears the burden of proof legally as to why the record should not be released into the public domain. This is where they have to document that proof. So the first thing you do is provide a description of the requested record. Well, why would you do that? Sometimes it's not exactly clear what the person's asking for. So you would say, we got your request. We think this is what you're asking for. Okay, you more or less put it in your own words. Then you provide the legal and factual grounds for why you're saying these records are not public. Usually you end up citing one of those 30 exemptions within the right to know law and making the connection as to why these records fall within that exemption. That's usually how it works. Then you put down the information for the arrow, because remember, this is the person who's legally responsible for responding to the request. All right, and how you contact that person. Then you put the date of the response. This is important because now another deadline is kicked in that the requester needs to keep in mind. And then you must explain what are the person's appeal rights. And usually it's that they have 15 business days to file an appeal with the Pennsylvania Office of Open Records. In most cases, that's what their appeal rights are. There is an exception, but we don't need to go into that here today. Okay, and within 15 business days, they would file an appeal with the Office of Open Records. Those appeals are usually submitted online, again, using our website, which folds right into our docketing system. Okay, when we receive an appeal, we look for 4 elements. We need a copy of the original request. We need a copy of the agency response, provided there is one. The person needs to tell us why they think the records are public, and they need to tell us why they think the agency is wrong with whatever response they may have given. If any of these elements is missing, we issue what's called a deficiency order and give the person 2 or 3 days to correct the deficiency. If they fail to do that, we dismiss the case, okay? It gets kicked out. If they are successful in providing all 4 elements, the case gets docketed. When a case gets docketed, it gets assigned a number. It's AP 2024- and a 4-digit code. It gets assigned to an appeals officer, and then we send out notice to the agency and back to the requester. In this case, now we call them appellants, describing what the process is. Okay, this is an important point for you people who were able to hang around here. This may be the most important slide you'll see here this morning. Everything I've talked about up till now regarding the right to know process is what I'll call an administrative process, okay? Other than the deadlines, there's a degree of flexibility, okay? When an appeal is filed, and this is kind of in response to Jeremy's question at the beginning of the presentation involving attestations and affidavits. When an appeal is filed, the Office of Open Records becomes a court. The Pennsylvania Supreme Court has defined us as an independent quasi-judicial tribunal. Okay, that's a mouthful. But basically, they're saying, now you're a court. And our decisions carry the weight of law. Therefore, anything you do needs to follow appropriate legal procedures. It needs to include appropriate legal language. Everything needs to be supported with an affidavit or an attestation, et cetera, et cetera. You can't just send us a sticky note that says, we don't got the record no more. Okay, it needs to be in the form of that attestation that I was talking about earlier. The courts require that of us, so we must require it of you. So when your agency receives notice that we have an appeal involving your agency, do not walk to your solicitor's office, because now another appeal or another deadline is kicked in regarding the appeal process, and your solicitor has a limited period of time in order to submit all the appropriate documentation to appropriately represent your agency before this court. Okay, if they fail to do that, they risk losing. because of meeting those deadlines. If you are an agency open records officer, do not try to respond to an appeal on your own. That's your solicitor's job, okay? And they must do this. They should know how to do it too. You still may be boots on the ground helping them out, but your solicitor is now the point person, okay? Hopefully I made that clear. It's a very important point because you do not want to lose your case based on a procedural error that your solicitor would otherwise be aware of, okay? Let's finish this up today now. The product of an appeal is what's called a final determination. We're required to issue them within 30 days. We may occasionally request an extension. These are legally binding. They carry the weight of law. They look like just what you would see coming out of your common pleas court at your county level, and no different. They're also available. If you have access to a legal service like Westlaw or Lexis, you can find them there. If you have the docket number, you can usually Google them, and some law firms will copy our decisions and put them on their own websites. There is the option of mediation. Okay, we have our normal adversarial process. However, when we send out those notices, well, first off, when a person files an appeal with us, we ask them, would you be interested in mediation? And then when we send out the notices to the agency, we include a form in there. Hey, would you consider, mediation's available? Are you interested? If both parties are interested, we pull the case from the normal process and assign it to a trained mediator here in our office. Reason being, sometimes all it takes is a conference call where you finally get the people talking to each other and they're able to agree to what can be released, what is going to continue to be considered confidential. Okay, and if the mediation should fail, no harm, no foul. We simply reassign it back to an appeals officer and go through the normal process. Okay, all I'm saying is that it's available as a tool for you to consider. There's no legal requirement that you must be involved with mediation, but sometimes it can solve your problem a lot more quickly than the normal process. If we issue an order and either party disagrees with it, they have 30 days that they can appeal it to the appropriate court. If it's a local agency, it goes to your county court of common pleas. If it's a state agency, it goes to the Pennsylvania Commonwealth Court. You've got 30 days. The Office of Open Records is not a party to the dispute. It's still between the original parties, okay? But you need to let us know, because we will either monitor the case, we may submit briefs, or we may ask to appear before the judge to argue our points as to why we ruled the way we did. Okay. And, oh, sorry, wrong button. Finally, well, first off, let me say, if you have any further questions, now's the time to get them in, because this is the final slide. If you happen to think of something once we end the presentation, remember what I said about reaching out to our office. We'd love for you to do that. But while we're waiting to see if anyone else has any further questions, additional resources, I kept mentioning our website, and I said it earlier, I'll say it again. It's simply the best government website you'll ever encounter. Honestly, it's updated 6 days a week with new information, new decisions, training opportunities, things that are going on in the world of government transparency. On there, we've got guides for citizens, guides for agencies. I mentioned the final determinations database, the case law index, and there's other stuff out there on both the Right to Know law and the Pennsylvania Sunshine Act, which governs public meetings. We have guidebooks for agency open records officers. It happens to be 78 pages. You can download for free. A lot of useful information there. Any training, any further training that you might be interested in. And also, if you're interested in transparency in general, you can subscribe to our Twitter feed. And every morning at 7 a.m., we will wake you up with all the news that's fit for the day with government transparency all across the country. Okay, Tony, thank you. do saldo submissions fall under, okay, I don't know what saldo is. You'll have to explain to me what that acronym means. Yeah, you're welcome, everybody. Glad to see all your faces here. Some of you folks have faces on your icons. That's really cool when they pop up. There's someone who has like a Doberman. Every so often they'll sign in, and I get this big picture of a Doberman on my screen. And right now it's like a 90-inch screen that I'm looking at with a big Doberman on there. Yeah, thanks, folks. Okay, still waiting to hear what saldo is. If you've had time to put that up there. If not, that's okay. Maybe you can reach out to the office. Oh, subdivision and land development plan submissions. Okay, that's going to depend on the context, Amanda, and how it's submitted. If it's part of zoning issue, if it's part of a zoning issue, that is governed by the municipal zoning law, which would supersede the right to know law. If it is considered a public record under the right to know law, though, you treat it just like any other public record. But it's going to depend on the context on how it's submitted, because I'm not intimately familiar with them. But I do know if it involves a zoning issue, then the Pennsylvania Municipal Zoning Act would govern public access to all that information. Because sometimes you have to have public hearings and the like with all that. So I'd say that's determined to there, not necessarily the right to know law. I wish were a little more up on that, but it's one of those deals where I know enough about it to know that I don't know everything. And I would say, take a look at the Municipal Zoning Act, and that will provide the answers for you. Okay, I think we're at the end of the presentation. I think we've answered all the questions that we have. I'm glad it was informative for everybody. Really some good questions today. You were what we call a hot bench, meaning that the judges were asking a lot of questions. So I appreciate that. And we'll be back in 2 weeks with another webinar. Stay safe, enjoy the warmer weather, enjoy your Easter weekend, okay? And we'll see you on the flip side. Signing off, take care, folks.